Welcome to another episode of the Legal Lowdown. I'm your host, Matthew R. Carpenter, an attorney, and today we are covering significant SEC developments that transpired leading up to the week of June 30th, 2025. In that time, we saw the SEC file a handful of new cases, and we also saw some cases resolved through settlements, which we have actually been seeing a lot of lately. Okay, so beginning with the cases that settled, we have SEC v. Marcon, which comes to us from the Northern District of Texas. In that case, the defendant Rajesh Marcon served as a representative for two brokerage firms, operate two companies, and he went off the rails when he convinced several people to invest nearly $3 million in what were supposed to be investment funds. But you know how this goes. They weren't really investment funds, and his plan was to use their money for his own purposes. To keep the investors at bay, he told them the funds were in long-term accounts, where the money had to stay put for 6 to 12 years. Clever. And in the end, the SEC caught wind and filed claims against Marcon. The defendants settled and consented to permanent injunctions. Monetary penalties have yet to be decided. Okay, going off of that, we have another offerings fraud case called SEC versus Alexander. That case is based in New Hampshire federal court. The SEC brought claims against the defendant and alleged real estate developers for lying to her clients to basically steal their money. So over the span of 6 years, beginning in 2018 and ending in 2024, the defendant solicited investments from more than 20 investors, telling them that the money would be strategically placed in real estate. But according to the SEC, that never happened. The real estate projects were completely fabricated. So basically, selling thin air to the unaware. Absolutely devastating for the investors who lost a cumulative total of more than $3 million. So what was her punishment? Well, the defendant settled, and she agreed to be enjoined from selling securities on behalf of others, and she is also barred from serving as an officer or director of a public company. A lifetime ban, as a matter of fact, effectively. Now, moving on from offerings fraud to false statements. Can I interest you in SEC versus American Patriot Brands, a case from the Central District of California where the SEC claims the defendants, a cannabis cultivation and distribution company, getting high, along with its executive members, made false statements to investors about the company's assets, its performance, and how the company's funds were being used. So they capped out about how much money they had, how well they were performing, and what they were doing with the money. But anyway, the California federal court sided with the SEC at summary judgment, and remedies and penalties are currently being discussed. Okay, so that was SEC versus American Patriot Brands. This doesn't sound very patriotic at all. Along with the false statements cases, we have also saw a resolution of a financial fraud case called SEC versus O'Donnell out of the Southern District of New York, where the SEC targeted two defendants. According to the SEC, Ed O'Donnell and Victor Bozo, who served as the executives of the telecommunications company Paratrium, that's the name. They engaged in a revenue recognition scheme, which basically means they allegedly lied about how much revenue the company was generating. Over several years, the defendant duo overstated revenue by amounts ranging from $10 to $20 million. In response to the SEC claims, the defendant settled, agreeing to both pay $225,000 in disgorgement and $60,000 in penalties. They are subject to permanent injunctions as well as criminal prosecution. Okay, so after dropping all that knowledge on those cases that wrapped up, I should probably cover one that just got going. So this case, SEC versus Mausner, out of the Southern District of California, deals with offerings fraud claims brought by the SEC against a defendant, Ian Mauser, and his firm, Evolution Lending. Apparently, Mauser had been prosecuted in a prior fraud case by the SEC where penalties were assessed against him. But that did not deter his appetite for more, people. After that, he used his company, Evolution Lending, to solicit nearly $400,000 from people for a crypto investment scheme. Mauser told them that he had a 30-year history of investing, but conveniently left out his prior run-ins with the law. And he also neglected to tell his dear investors that he had no intention of complying with the disclosure rules required by the SEC. So if you've been keeping track of these podcasts, you could probably guess what happened by now. In the end, the capital that Mausner raised never made it into legitimate crypto investment funds. And for that reason, the SEC filed this new matter against him to resolve the offerings fraud that allegedly occurred. Okay, so wrapping this all up, what did we learn? Well, to me anyway, it raises a huge question how regulators actually track and stop people like this. What does it mean for you, the investor, trying to check someone out, right, before you put your money in their hands? That's a tough question. How do you stop someone determined to break the rules even after they've been caught multiple times? There are tools. You can check the SEC's database. They list disciplinary history, but even for fraudsters, that can be slippery. The key takeaway, though, is don't just check that these people are registered. You absolutely must check their disciplinary history too. It's often right there in the public record. If you look, it's probably the single best step to avoid, a Mausner type situation. And so, stepping back a little bit more, looking at this from a higher level, what's the big picture for our listeners, right? We've seen these patterns of outright fabrications and offerings and corporate misrepresentations, even repeat offenders who slip through the cracks. So the common thread to me is that, there's a significant need for vigilance. You actually also hear this from the DOJ. They give podcasts, and then the SEC, they post YouTube videos, and they talk about this all the time, right? Like, consumer vigilance is one of the key things that will prevent these types of fraud schemes from proliferating. It really comes down to critical thinking about everything, especially claims that sound too good to be true, because the DOJ just recently said they probably are, right? You got to verify people's credentials. You got to understand what you're actually investing in. The regulators are definitely active, as we've seen, but ultimately being an informed investor is your best protection. Okay, so here's one last thing for you to think about. As regulators start building frameworks for new assets like digital tokens, how might these proactive rules shape the future of financial fraud in emerging areas? And what new challenges, maybe ones we haven't even thought of yet, might pop up for investors as these digital markets continue to grow? All right, that's all for this episode. Thank you for listening to the Legal Lowdown.